allowed to engage in those excesses. And so I am not against, I want to set the record straight that I'm not against calling someone to account if that person threatens another person's life or threatens another person's property, whether the target is a politician or a private person. What I'm against, and I was consistent throughout President Akufo-Addo's administration, that there is a certain law against false publication that was used some time back. I think when President Mills was president, Akufo-Addo, who was then the opposition leader, made a statement in South Africa and condemned that law. When Akufo-Addo became president in February 2022, President Mahama wrote a direct open letter to Akufo-Addo condemning arrests that were made using that law. Now, President Mahama becomes president, and the same thing is continuing. And that is the reason I also wrote an open letter to the president. And I just want to use an example of my own encounter with free speech and the repercussions. Between 2015 and 2022, I was sued 11 times for defamation. 4 of those suits came from 2 different organizations, 2 from Lighthouse Chapel and then 2 from SML. The Lighthouse Chapel has gone to trial and the SML one is yet to start. But the rest of the 7 suits, they all abandoned the suits just after I filed my defense. And guess what? In all these 11 suits, those who accused me of defamation said what I published wasn't true and that it was false. So the point I often make is this. If in each of these situations, they didn't go to court to exercise their right under defamation, but use the criminal route and then use that frivolous charge of false news and causing, I would have arrested, I would have been taken to the police station, I would have been put in cells or remanded, and then eventually the case goes to court and then I'm freed. But we cannot take out the fact that I would have a section of analysis number 12 video against somebody who claimed it was false. Someone published something against the Ashanti regional minister and then the Eastern regional minister that they were involved in Galamsey. If that publication was false, I agree that they should sue the person for defamation, but they used the police. They arrested and detained this person, and then later on, the Ashanti regional minister I know sued for defamation. These arrests, in my view, are arbitrary. They are only used mainly to target people who speak against the incumbent. People like Abronya were insulting even within that administration, but they were never touched because their government was bad. You put a journalist photograph on look, you don't know him, he lives in Medina. If you get him, attack him, whatever happens, if he comes here, attack him, and I will pay. That journalist was shot and killed, and nothing was done to him. I don't think there are more offensive speeches than some of these examples. And in the current administration, some members of the NDC administration hail people whose job is to insult and vilify and lie and malign for a living. But because they are doing that against opponents of the NDC, they are seen as heroes. So the point I have made and consistently been making is that this law against false publication, in my view, isn't a bad law, but the political class, especially the incumbent, always use this law to target voices of dissent, voices of opposition, whenever they are in government. In opposition, they all criticize those actions. And I gave examples of how Akufo-Addo criticized it in 2011 when he became president. They used that law. When Mahama criticized it in 2022, he became president. We are seeing it. So dialogues of this nature, in my view, are important so that we decide, is it a law that should go or it should stay? Someone said, okay, if you are watching national and maybe Uncle Book White's play at the National Theatre, and then somebody shouts, there's a bomb, or somebody shouts, there's fire, and then there's a stampede and people get hurt or even die, should we say there shouldn't be a law to hold that person accountable? I don't think it is wrong to keep a law that will hold such people accountable. And this law says the false publication should cause fear and alarm. In most of these circumstances, nobody even heard of the publication. I didn't hear what Abronya said. I didn't even see what Samuel Amadato published in that blog. I didn't see what this person who alleged that Ashanti regional minister was involved in Galamsey, and not just me, but many people didn't see. And if you look at the content of those publications, I wonder how Abronya's accusation against a judge will cause fear and alarm in the country to the proportions that this law should be employed. So I am hoping that a discussion of this nature, maybe we'll share ideas and find out, okay, should the law go? There are already laws that deal with threats of harm and others. If somebody says they will kill the president, I don't think this is free speech, even though I still think that some of them should be, the security agencies should assess every situation before acting. Because there are people who are on social media and they live by some of these outrageous things. They want to rage bait and get attention. And there is evidence that when people get into some of these instances, they get a lot of followers. Someone killed the CEO of United Insurance in the US, and within a week, his social media following just blossomed. So there are people who live for these controversies. And so even if the security people are going to every day be arresting some of these wayward, and let me excuse my language, any mad person who backs, you go to arrest him or her, you may not have the time and resources to actually follow people who are the true threats against the protectees, the president and the very influential people that we try to protect. So I hope a meeting of this nature should be able to at least, we share ideas, should the law go, if it should stay, how should we ensure that it is not abused? And as I speak, I don't have the trust in the political system we have now, that given the power, they wouldn't this law. But I'm also a bit hesitant to say that we shouldn't have a law that would punish people who can cause real fear and alarm and get people into trouble. So these are my initial comments, and I would want to apologize once again that there's a program which has already started and I had to sneak outside to make this contribution. I would have really loved to be part of this all-important discussion. Once again, thank you, Penplusbytes, for creating this platform. Thank you.
Thank you, Manasseh. If you could take a few minutes, let's just see whether somebody in the audience has a question for you. Else, then we could. Yes, I see a hand up. Joseph Sam.
Yeah, thank you very much for the presentation. I really enjoyed it, even looking at how we are politicizing the legal sector, or let's say a legal bill. My question is that Manasseh's submission was roughly looking at the extreme ends, where on one side it's good and the other side, because of the politicizing of it, it has become something that we have to look at. My question is, what is the role of the youth or even academia? Because I think I would want to contribute to this. I think I would want to stand up and sanitize the system in my own way. So my question is, one, as a youth, as a young person, what is my role in this? And two, what is the future of academia in it? Because most of the students, most of these youth are churned out from the university system in research. So what is the role of academia in this? Thank you, and over.
Okay. If there's one more question, then Manasseh
Okay.
can answer and go. Otherwise, then, okay, over to you, Manasseh.
Okay, thank you. I think young people should desist from insulting to be recognized. There are many things people can do to get recognition. Trust in your ability to use your God-given talent, the learning you do in school, and then work hard and be recognized. There are many people who insult and they get rewarded politically. So there are incentives for such outrageous comments. And they often say, if you can't beat them, join them. But I say that if you can't beat them, don't join them. Refraining from it is the first step of the contribution. And then condemning it within your circles is something else you can do. And if you have a platform, engage in healthy dialogue. Academia, in my view, besides the research and the knowledge they produce, I think should be also concerned about the character of the young people they mold. I have just returned from the US, and when I was going to the US to go to school, I had 1 year fellowship at Harvard and then 2 years at the University of Nebraska. When I was living here, they said, oh, be careful. These white people don't corrupt your values. And I got in there and I realized that these people have values. I learned a lot of values, even from my students. And so the point is, we often talk about the moral decay in our society and others, but I think beyond imparting knowledge, academia should be interested in shaping the morality. And when we talk about morality, Ghana, we often talk about sex, but there's more to morality than that, and the value system, so that a young person coming out of the university will know the values of hard work, truthfulness, community service, and integrity. And if you have these things, sometimes what you say would even, how do you call it, be guided by them, so that you don't go, a certain minister's very outrageous words, insults, and others were played back. So, well, our party was in a position, we needed someone to speak for the party and all of that, and I had nobody was doing it, so I had to do it. The person wasn't defending the content of what he said. But today, if you said those things against that person, you are likely to be in trouble. But this person, excuse my language, I saw one video, so that Akufo-Addo is a thief in chief, and his mate, who is Baumia, has learned how to steal more than his master. All of these things are things, when you say they will arrest you, somebody said it today, he's a minister. These are the things that encourage others to engage in these outrageous statements. But I believe that a young person with the right values, training, and education should work to be recognized and not insult to be recognized. Thank you so much, but unfortunately, I have to go, please.
Thank you, Manasseh. Thank you. We understand. We absolutely understand. If you have more questions for him, please put it in the chat, and I would personally email it to him so that he can answer it. Okay. Thank you so much for your time, Manasseh. I think he has set the tone rightly for our next section in this dialogue. We are now moving from the journalist lens to the legal and regulatory one. And I will hand over to my colleague, Jerry, if Jerry is ready, who will introduce our panel, Dr. Nafisa and lawyer Tanko, and take us into the heart of this discussion. So, Jerry, over to you.
Thank you very much, Precious. Good morning to everyone. And thank you also to Manasseh for setting the tone for us. He has actually given us his lived reality from his work, both in the newsroom and his investigative work, and even writing his books. We've got a piece of, some of the things that he did in the past. My key takeaway is from his presentation, is a statement that the law against false publication is not a bad law, but how do we ensure it is not abused and respects individual rights? So during this segment, sorry, I did not introduce myself well. So I'm Jerry Sam. I lead the team at Penplusbytes, and I'll be moderating the next session, which we will have a panel. And during this segment, we will have conversations around how Ghana enforces against genuinely harmful content without criminalizing speech. Together with my two expert panelists, we will try and put the next two vantage points, how the states communicate around information integrity and how the law actually permits or forbids it. My first panelist is Dr. Winnifred Nafisa Mahama. I see a video is on. He's a longtime friend. In fact, the two panelists are all longtime friends in Penplusbytes, and we've been in this together trying to information integrity. Just to do a brief introduction, Dr. Winnifred Nafisa Mahama, I don't remember the last time I mentioned your name in full like this, but I normally call her Acting Director of Ghana's Information Department, ISD, where she leads efforts to strengthen public communication, access to information, development communication specialist. She previously served as head of the ISD's Access to Information Division. And Nafisa is widely recognized for her work in promoting information integrity, combating mis and disinformation, and advancing response of digital technologies and artificial intelligence in public communication. During this segment, Nafisa will help us understand some of the initiatives by government communication around these issues that we are addressing, and ISD's role in the information ecosystem. Next on my list is lawyer Tanko Musah, who I have also not mentioned his name in full like this before. I always call him lawyer Tanko. He's a legal practitioner and a lecturer at the University of Media, Arts and Communication. My alma mater, when I was there, was called GIJ for short. And he has a strong background in media law, communication, and digital. He has extensive experience in engaging with the issues at the intersection of law, media, and particularly in the areas of freedom of expression, regulatory frameworks, and governance of digital spaces. So during our conversation, Tanko will help us with the constitutional provisions, media law, where is media law lens, where protected speech ends, and where criminal conduct begins. Without much talking, I feel that my intro is getting very long now, so I'll just go into why we are here. So Nafisa, I'll start with you. If you can, I just want us to take it from where Manasseh to understand the space. So I would like to hear, from your end, what ISD is doing. What's your response to the rise in mis and disinformation in Ghana? The recent arrest of alleged false news, as Precious introduced us to it. Yeah. The public concern about, the criminalization of speech in Ghana. Over to you.
Okay, I think my mic is on. Okay, thank you so much, Jerry, and thank you for this opportunity. And hello, Tanko. He's my colleague, and we have been in this for a while now. I'll give a little background or perspective so that we can move on in this discussion. And pardon my voice, I'm under the weather a little bit. Now, the rapid growth of technology, and especially social media and digital platform, has in a way improved access to information. And when there's access to information and more public participation, there's also people find a way of working through it. And so it also gives a rise to the spread of misinformation and disinformation and all its allied force. We all know from what Manasseh has given us briefly this morning that misinformation and disinformation can undermine public trust and create panic or damage reputation and threaten public safety in one way or the other. The recent debate surrounding alleged false publications and arrests highlights the need for a balance between freedom of expression with information integrity, because obviously we all have a right to express, but there's a limit to any freedom or rights that anybody has. So freedom of expression is a constitutional right that we all know, and it is essential for Ghana's democracy. However, as I've mentioned, every right carries responsibilities and should be exercised responsibly. Okay, IEC is not a law enforcement agency. Our primary responsibility is to provide timely, accurate, and credible government information to the public for them to make informed decisions. So we do that through proactive government communication and all that, a lot of public education, the promotion of the right to information law, okay, media information literacy and all that. Promoting the Right to Information Act enables citizens to obtain verified information directly from public institutions and sources. And so then that gives them the opportunity to rely on verifiable information and not on rumors. And so we embark on public education campaigns to encourage citizens to go to the right source of information, because we realize that where there's vacuum, it gives room to a lot of misinformation. And we also do that through some of the media information literacy campaigns that we embark on. My point is that the most sustainable response to any misinformation is not really direct enforcement alone. It is an informed public supported by transparent government communication and access to information and media literacy. So I'll pause it here. We'll come back to it and then we'll go further deep into it.
Thank you very much, Nafisa. So that sets the tone. I like that you say that every right, carries responsibility. So
exactly,
what our rights are, what the obligations of the lawgivers are, and all of that. And that rightly, brings in Tanko. But Tanko, I want, sometimes we just use the words mis and disinformation and hate speech, rumors, and we bundled all of them together. So under our current laws in Ghana, how are misinformation, disinformation, hate speech, and lawful content distinguished? And which statutes? I mean, we have the Electronic Communications Act. I remember you did some work for us to see whether we actually do have the appropriate laws in Ghana in dealing with these issues and whether they are still relevant in the digital age. So which statutes? Is it the Electronic Communications Act, Cybersecurity Act, Criminal Offences Act? Which of them gets invoked when any of this misinformation or false publications happens? So over to you, Tanko.
Thank you, Jerry. Good to see you and good to see my sister. I am worried that my sister, Dr. Mahama, is losing her voice. It's too early because Ghana has not even played. And so I'm just worried for my sister. But hey, good to see my sister in the Ghana jersey. You have actually shamed us, myself and Jerry. We should have been in our Ghana jersey.
I'm wearing my jersey under my shirt.
Okay. Then you are better than me. Yeah. You're better than me. But yeah, good to see you guys, and Penplusbytes, kudos to you for the work you're doing. And I think it was very important that you put it in context that this discussion is not to, if you like, take sides, because this issue is being litigated at the highest court of the land, the Supreme Court, to find out whether or not in the current architecture of our constitution, whether sections 208 of the Criminal and Other Offences Act is constitutional or not. So by and large, we would be very mindful not to go deeply into any conversation or discussion that would attempt to, if you like, determine the merits or demerits of the case before the Supreme Court. That's not our intention. Our intention is just to make sure that these matters are brought into the public domain for information and educational purposes. The question as to which law, you are absolutely right. The problem we have with our framework is that misinformation, disinformation, hate speech, and all those things, our laws actually doesn't uniquely distinguish between these laws. It doesn't really distinguish them. So that is what has given the law enforcement agencies to usually look at which law they can come under, and they usually go under the older laws, So what they use in doing the, if you like, distinguishing is, for instance, as you know, the difference between misinformation and disinformation is basically based on what? The intent. And so they look at that. And then, of course, when you look at also hate speech, they actually look at whether or not the speech seeks to attack or demean or promote hatred or negativity against a person or group of people based on a certain characteristics, whether it's their religion, whether it's their, ethnicity, or whether it's their gender or race. Do you get it? And then you have the broader one, the unlawful communication, which is broad, which tries to take care of the digital and offline publication that breaches public order or national security. So if you want to look at whether there is any specific law that differentiates them, there isn't that law. But by and large, what happens is that you see that they come under some of those old laws. So if it's about publication, you would see them coming under Section 208, which talks about publication of false news and all that. And then if you talk about, if you like, and Manasseh talked about the issues about hate speech and all those things, it is and then the Electronics Communication Act. So there is no specific law per se, but they come under a number of laws to try and capture some of these things. And that is where the opportunity, or if you like, the unfortunate aspect of subjectivity hiding behind the broad nature of those terms in those provisions and the lack of specificity allows for abuse here and there. And that's where the concerns are. And I'm sure as we go into the conversation, we will look at some of these things. But yes, but to answer your questions, we have a problem because our law does not necessarily distinguish between these laws.
Thank you to both of you for sensing the tone. So, I mean, then it means that enforcement is at some point very subjective. If I get you, Tanko, and I would like to stay with you. What concerns do the recent arrests raise about due process and proportionality then? And just to add that, what threshold separates a matter warranting criminal investigation from a civil remedy or no action at all?
Yeah, so as Manasseh said earlier on, I don't think, we all want in a democracy to promote freedom of expression, freedom of speech, and fundamental human rights. The guarantee of fundamental human rights is the hallmark of any constitutional order. So everywhere, nowhere in the world would you ever find any provision, any law that grants people absolute freedom. Because if you do that, you are promoting chaos. You are likely to promote chaos and all those things. So almost all the laws, all the constitutions, even like the international conventions, they do recognize that whenever you are given rights, those rights have to be exercised in accordance with the law, and you have to be responsible in the way you exercise them. Now, the problem we have in our part of the world most of the time is that even though we want to use the law to go after people, we don't want to be subjected to the same law that actually points us to how, when, who can use that law. Because yes, freedom of expression is guaranteed, but it's not absolute. It can be interfered with, it can be curtailed if it meets it goes beyond certain thresholds. And there is an international standard. Anytime you want to, come in and interfere with somebody's fundamental human right, remember you are interfering with that fundamental human right. All these laws that we've talked about, Section 208, Electronic Communications Act, and all those things. These are subordinate laws. These are laws that actually, when they come face to face with the Constitution and they are at variance with any provision in the Constitution, they have to give way because the Constitution is supreme. So when the Constitution has given you a right, you cannot use a subordinate law to take away that right. But this is a situation where when you are trying to actually interfere with that right, you have to make sure that it's in accordance with law. In other words, you need to be able to point out to a law that allows you to do that. And yes, they are able to say, well, you've breached Section 208, you've breached this Electronic Communications Act. So yes, they meet that requirement. But there is also the issue of necessity. Is it really necessary in the current circumstances? If you look at the facts, is it really necessary for you to want to interfere with that person's fundamental right? And even when they meet the threshold of necessity, there is an issue of proportionality. The action you are deploying to undermine the fundamental human right that has been guaranteed, is it proportionate with the danger that actually we are facing? You understand? And this is where we fall short. Because frankly, when you look at almost all the instances that these laws have been deployed, usually it's not to achieve a legitimate aim. The aim is either because maybe a politician feels embarrassed, or maybe somebody feels that, no, who is this person to do that? It's not to achieve a legitimate aim. It's to leave mostly political interest or parochial interest. And even when they try to achieve a legitimate aim, the proportionality thing, why will you want to actually jail somebody, for speech, when we have actually moved away from that since 2001, when we repealed the criminal libel, and now the model, standard is that jail should be reserved for violence, not speech per se. But if you have to jail people for speech, it has to be to achieve a legitimate aim. There should be transparency, and the decision maker should not be somebody who is influenced by other considerations apart from the public interest. And this is where we're having challenges. And that's why recently, when we were putting together a document for the consideration of the constitutional committee that was set up, we were arguing that, well, it's got to the stage where if you want to actually arrest, or you want to go in and interfere with the concept of freedom of expression and freedom of speech, there has to be some high thresholds that you have to meet before you can even go for that arrest. We are even arguing that we need to also consider whether or not, it should not be left with an independent person to do that assessment anyway. And if you have gone in because you are arguing that the threat is imminent, then within a shortest possible time, it should come before an independent person or body to be able to look at that. But this is the situation where we have a situation where people are arrested because of their speech. They are not given bail. Meanwhile, bail is not supposed to be considered for punishment, because, mind you, even if somebody commits the most heinous crimes that you can think about, they are innocent until what? They are proven guilty. And so if somebody is innocent and then you just go there and you deny them bail, mind you, the right to free movement is a constitutional right. And you go and curtail that right to free movement because they have expressed their opinion, or they make certain statements that you consider unacceptable, and denying them bail. And then ultimately, after maybe a day or two, when you give them the bail and the case doesn't proceed, then it sends a signal that the very reason why you went in the first place is not for a legitimate public interest, but a parochial interest. But nobody in a democracy would be able to, convincingly argue that people should be allowed to say whatever they want to say, when, where, without consequences. There should be consequences, but it's the nature and the way those consequences are deployed, and the who that deploys that consequences, and the selective nature of deploying that consequences is what is raising the concerns, which is legitimately so. But otherwise, yes, we have to, because in this day and age of the social media and all those things, people are hiding behind that and actually engaging in acts that are purely reckless, and that has the tendency, yes, to really plunge us into a situation that we don't want to be plunged in. But we can't also allow that emotional if you like, blackmail of the fact that people may be saying things that can plunge us into a disaster, for people to hide behind that law, especially when the law is so vague, they are so broad, and then people can abuse them. We need to actually come out with a legislation that is very specific, that is actually dealing with issues about legitimacy, proportionality. That is the only way we can actually proceed.
Thank you, Tanko. I have a lot of questions, follow-up questions on all the things that you said. I'll just ask just one, whilst I let Nafisa rest her sore tooth small. But I'll come to you very soon, Dr. Nafisa. Tanko, just a quick follow-up. You kept on mentioning legitimate aim. For me, as a layman, one of the legitimate aims for applying these laws is as a deterrence, and also to sanitize our information ecosystem. What other legitimate aims, are there that we need to apply these laws? And then also, how do we differentiate that? Okay, for this speech that I made, it will require, or warrant criminal investigation, and which ones will fall under civil remedy, and which one will not even require an action at all, to say that as for this, it's just freedom of expression. The person just spoke freely as a way of participating in a democratic discourse, for instance. So just a quick one on that, Tanko, and then I'll go to Dr. Nafisa.
So you see, any limitation on the freedom of expression, freedom of speech, and media freedom should be interpreted in a manner that promotes and enhances the rights to freedom of expression, freedom of speech, because of the important role they play. And any interference has to be what? Minimal. Now, the presumption is more on openness. In a democracy, the presumption is be very open, be transparent, let people speak their mind as far as they can. And so the presumption is in favor of openness and transparency. And the issue is, we have our Criminal and Other Offences Act that actually indicates what is criminal and what is not criminal. But the threshold, even if it's on the borderline, the threshold should always be about whether or not that speech, that statement that the person has made, that thing that the person has published, does it really cause fear and panic? Or it's more of it has the tendency to cause fear and panic. So there should be real possibility of causing the fear and panic. But as it is now, it is just based on assumption that that is what it would do. And that is where there is the problem. And it should, issues about interfering with people's freedom of expression and all that should be reserved for very serious issues. For instance, issues that threatens our national security. Do you get a point? But if somebody, a harmless person like me, I say that, I am going to bring Ghana down. Or, recently there was a statement where they say somebody said something to do with the economy. How is that going to really promote fear and panic to the extent that it would bring our economy on its knee? It doesn't. So it should be reserved for those serious. That's why if you look at the international conventions, they say that, frankly, if you want to use them, you should deploy them for serious national security issues that threatening our health emergencies and all those things, not issues about somebody who is acting negligently or recklessly as a result of whatever it is. There are other avenues you can use to deal with such a person, but certainly deploying the criminal a law against such a person, weaponizing the criminal justice system, would do the opposite, because it would make people recoil. And when people recoil, who are the beneficiaries? The ones who don't want transparency and openness. And when there's no transparency and openness, who suffers? Democracy suffers. And who are the people who are the custodians of democracy? We, the people. Because in a democracy, power emanates from us. We give power to who we will. And so if we give you the power to exercise it in the way we want it to, you as a public official, your, if you like, ability to tolerate dissent, to tolerate criticism should be higher than an ordinary person, because we have put our resources at your disposal. And as a result of that, we are even giving you certain privileges that nobody else have. But we are not saying that it should be a situation where, like Manasseh said, how can you go and threaten that somebody should be killed? That certainly is a criminal thing, because threat of harm is not acceptable. Because what if the person also starts taking steps to defend him or herself? You are promoting chaos. So yeah, things like this, certainly we should take action. But if the politicians can just stay away, and be honest to themselves, and when they are in opposition, what they say in opposition, when they come in government, they should still recognize that, I think we will be making a headway. But the way the politicians are playing chaskele with this issue, it's making it a vicious cycle, and we will not be able to achieve any effective and efficient way of dealing with these matters.
Thank you, Tanko. For our international participants, chaskele is basically back and forth, and
back and forth, yeah.
So just to define that. All right, thank you so much.
Thank you.
I mean, that's a lot of education you've given us. So, Dr. Nafisa, Tanko has really set the legal red lines for us. What I would like to find out from you is that what should guide the escalation toward enforcement, versus corrective communication. How can we build that critical mass of people that understand the legal red lines, or what should trigger what they say that will refer them to the law itself? Against what measures can we take to correct this things from happening itself? You're muted, Doc. Doc, you're muted. Correct.
I was muted from your end.
Yes. Okay. So
all right. Yes. Anyway, the guiding principle, I think, should be proportionality, because not every inaccurate statement should lead to criminal investigations and prosecution, as Tanko has said. Many of the cases of misinformation arise from misunderstanding, or from misinformation itself, or incomplete information, or genuine mistakes. In such situations, the preferred response should be corrective communication, or clarification, or public education, or citizens' engagement. And from where I say, as ISD, as public information officers, we believe in prevention, which is better than enforcement. So our preventive interventions mostly have to do with continuous public education and promotion of right to information, media information literacy, and timely dissemination of verified government information. And I keep emphasizing on the timeliness, because when there's vacuum, that's where people get to play all those things. But where there's evidence of deliberate deception or incitement to violence, fraud, or threats to national security, as Tanko has said, or any other criminal conduct, then the appropriate investigative and law enforcement agency should act in accordance with the law and due process, as Tanko has emphasized. Our role is to support them in clarifying or providing factual information to the public on the processes or the procedures that has to that is going, or promoting public understanding without interfering in the investigation itself. But what I can say is that public education should always be the first line of defense. Enforcement should be reserved for conduct that clearly violates the law and causes demonstrable harm. And so uninformed citizens, or somebody who has access to verifiable information, will not, or is not expected to be indulging in churning out information that will cause harm or fear or panic that will even inure to the person any criminal charges or anything of that nature.
Thank you, Dr. Nafisa. I'll stay with you since we're almost where I want to go, which is this is our last segment for this panel, where we'll be looking at reform and what comes next. And I would like to find out from you, because I mean, you kept on emphasizing that enforcement, or as I gathered, enforcement should be the last resort after corrective communication has been tried. So where does ISD invest, most of your energy across corrective communication, be it media and information literacy, enforcement referrals, where people can even access the right information? Is that balance right? How should it shift with the new legislation from the Ministry of Communication, for instance?
Okay, so I'll start from where I left off. To say that our greatest investment is in the media information literacy, citizens engagement, strategic government communications, and all that. And every day, our work every day in ISC is to ensure that government information is accurate, is timely, is accessible, and is transparent. And through our regional and district offices, we conduct various nationwide public education campaigns to help citizens understand government policies and recognize misinformation and have access to government information. We continue to promote the right information as a key tool to improving transparency and reducing reliance on rumors and speculation. Okay, so we also expand media literacy, media and information literacy, information to citizens, or to help them to understand that it is important to verify information, or to be able to recognize manipulated content or detect AI-generated misinformation and deepfakes, so that they, at the end of the day, they become more responsible digital citizens. Going forward, greater investment should be directed towards federal media information literacy, because I would say we are just at the beginning of embarking on this information literacy, which is very important for the citizenry. Digital literacy is very, very, very important. I know the Cybersecurity Authority does some. We stand as a collaborator in all this because we are positioned nationwide, and we have the technical know-how, we have the expertise to be able to embark on this awareness creation and promoting of the rights to have access to information. Enforcement referrals will continue where necessary, but they should remain exceptional instead of routine, because we believe that once the education goes out and people are aware and people know their left from their right, it will minimize all these churning out of information that will bring fear and panic. The long-term solution, I believe, to misinformation is not really enforcement alone. It lies in strengthening public education. You hear me keep saying public education and promoting access to information and all that, because they all work into what we call the behavioral change of people. If people are used to a way of doing things and you are telling them to shift and move from relying on these sources of information, it's not a one-off event. It's a continuous event. And so we have to continue that aspect. And we, as ISD alone, cannot do that. We do that in collaboration with other institutions, be they public institutions, and then CSOs and other things. And we've been doing that we started that with Penplusbytes as well, with our new information rigs, going down to the rural areas to get people to understand and appreciate that. And so that is the way forward. And I think that is the way we should move from this, to be able to minimize that impact of all this misinformation and misinformation and all that. The law, yes, Tanko has mentioned about there not being a specific law that addresses this issue. But in coming out with a law, I know Ministry of communication has begun a process. We've all sent in our inputs, and we are working at it so that at the end of the day, the thin line between freedom of expression and the abuse will be very minimal, and it will be clear enough for anybody to know that if I'm moving towards this tandem, I'm surely going to plant myself into problems. But I have to express myself, but this is the channel I can use, and these are the ways I can use and protect myself and be a responsible citizen of the nation.
Thank you. Thank you so much, Dr. Nafisa. And I like that you mentioned the work that both the ISD and Penplusbytes did in recent times in our work called the Caravan of Hope, where we try to take media information literacy to the grassroots and how to reach places. And I'm sure these are some of the interventions that we need to do more of. I was actually going to mention that the ISD is using so much, but sometimes when you're not within their network, you don't get to see. But we have to all feel it, and I will encourage all of us to visit their social media platforms and websites to see what they are doing, and so that we can all get involved. So I'll move swiftly back to you, Tanko. We mentioned the Ministry of Communications' new law around mis and disinformation. How should that new legislation close the gap? We're still doing, as Nafisa mentioned, we are still inputting into the law, trying to make sure that it serves the purpose of encouraging participation in our democracy, but not infringing on freedom of expression. How can this new legislation close the gaps that allow misuse or selective enforcement, as you mentioned before? And what does a rights-respecting but enforceable framework look like in practice? You're a technical person, so I'm making a question very, very technical. I hope I haven't confused you.
I'll try not to give you a technical answer. But I always get overly impressed by my sister and the work they are doing. And frankly, I am even amazed when in the introduction, you were still introducing her as acting. Why is she still acting? My sister, don't be embarrassed, but you they have to confirm you. I don't know why you are
supposed to ask for the confirmation. We have to.
You're acting for it. These are all, if you want to loosely look at the whole thing, indirectly, it affects the ability of the person to do the work that we're supposed to do. But yes, I mean, as we said, we are not saying that we shouldn't look at legislation to go with the 21st century, because if you look at Section 208, which is in the 1960 Criminal and Other Offences Act, clearly time has really overtaken that law, right? Yes, I mean, they came out with a modern one in the Electronics Communication Act, which was supposed to be modern, but there again, typically, they still maintain some of the, if you like, the draconian, if you like, aspect in there. So in the 21st century, when you are coming out with a law to do with issues about speech publication, you need to be mindful of the fact that the train is really driving very fast. And sometimes if you try to legislate on certain things, you cause a bigger harm. So like we said, the new legislation should actually all still look at legality. The offenses should be precisely defined, right? Define the offenses. We should do away with all those victims like false news, offensive, insult, threat to public order, and replace them with harms-based definitions. And then I mentioned earlier on about the legitimate aim. Criminal sanctions only for content causing direct or imminent or serious harm. Issues about violence, incitement to violence, child exploitation, those are issues that we could say that are legitimate. And then no prison for speech, unless it directly causes a direct harm or so. Otherwise, I mean, even if we have to deploy the criminal justice system, well, fine. Maybe a community sentence. They're trying to come up with a community sentence. So if I say something that is unacceptable and that has a tendency to cause disturb our peace, and get me to go into my area and clean the stinking gutter. Everybody will see me doing that, you know, but not certainly to be sending people to prison. And then due process. Due process has to be followed, and then the independent oversight. They should have provisions in there, although there are provisions in there that deal with the independent oversight and something. But there's something that I think that it might be controversial, but I think we need to look at it. Because, you know, even the 1992 Constitution, how many years is the 1992 Constitution? Right? And how many times have we tried to do something about it, knowing very well that there are issues with it, but we are refusing or failing to do it because either somebody thinks the status quo helps them. And then look at the Section 208 that we're talking about, 1960. We are arguing and arguing that we should get rid of it, and nobody is doing anything about it. So I am thinking that any law that we would bring that has actually that interferes with people's fundamental right, we should have a clause in there that says that maybe after 5 years, go back to Parliament for them to review that law and see whether or not that law is actually needed in its current state, in the current circumstances. Because by then, you would see how it is being abused and all those things. But I am saying this on the basis that we would one day wake up and have a Parliament where the majority don't vote one way and the minority don't vote one way. We will have a Parliament where the overriding objective would be the public interest, so that when such a law is brought back, they would look at it in the public interest and not what would inure to my party to make my party popular, so that when I go back to Nafisa and ask for her mandate, she will give me the mandate. For me, that is what I'm looking forward to. But frankly, I am getting a bit worried about coming out with laws and then it gets stuck in there. We have challenges. Nobody wants to do anything about it. The people are powerless. The people who have the power to initiate, they won't do it, and there's nothing we can do. I am thinking that we should have a clause in there that makes it mandatory for it to go back to the people's representative, whose only responsibility is to make laws, to look at it again and see whether that law has to be maintained in its current form. But I want to also wrap up by saying that if you look at the recent Freedom Index that came, Ghana did extremely well. And people are wondering, how could Ghana be doing well after all these arrests and all those things? It is because of the way they define freedom. And there again, they still define freedom that it goes with what? Responsibility. Freedom of expression goes with responsibility. So even though there has been those arrests, when they analyze it, they look at it, they realize that frankly, some of the things that people said that led to, if you like, the invitation and all those things are things that shouldn't be acceptable in a democracy. That's why people are saying that, oh, maybe they didn't take that into account. They really took that into account. Because when they do that freedom index, it is for the previous year, but they take into account any developing issue that may affect it. And they took all those things into account. And even still, we did extremely well. So we are not doing badly, but we always have people, bad notes in every calabash here and there. And therefore, when you are legislating, you have them in mind. But don't try to legislate with the bad ones in mind, and then it defeats the very purpose for which freedom of expression is actually enshrined in our constitution, because it helps us all. It helps a thriving democracy. That is the only way we can hold the people we have actually put at the helm of affairs accountable. And that's the only way we can promote, civil society.
Thank you very much, Tanko. I like the bit about putting in a clause in all these new laws to say that 5 years' time or a certain time frame, we should go back and review it. I mean, look at the Criminal Act, is it 1960?
1960.
We are still applying it in the digital age, where now there's so many different platforms that was not in existence in 1960. Yeah. I want to go to our next segment, which will be the Q&A. But I suspect that nobody has questions, because you guys have been, you've done justice to all the angles of what we're talking about. That I'm not sure if anybody has questions. Do anybody have a question? If not, I can quickly read the one. There's one in the chat, which we got through one of our platforms.
Yes, please.
Oh, there's a question. Okay, Samuel.
Yes, please. Yes.
Okay, go ahead, Samuel.
Good morning, everyone.
Morning.
My interest is in...
Let's keep our questions very short, please.
Yes, my interest is in what constitutes problematic speech, right, for which people will be arrested. Because, I mean, on social media, we feel that we have the right to speak. So I would want your speakers to take me again through what constitutes problematic speech, so that some of us can be careful, and then when we engage others also, we can educate them properly on how to speak but still stay on the right side of the law. Thank you.
Is there any more question? I think that also ties in what Harrison just asked, ties in with what we have in the chat, that this person shares opinions, even sometimes reposts some of the things that others have said on WhatsApp, or is vetted from Facebook. How would they know that what they are sharing could get them arrested? And where is the line between my opinion and what the law considers false news? So, Nafisa, I will start with you. I mean, how would I know that I'm infringing the law from what I've said?
Okay. So, when Tanko was speaking, you were also speaking, you talked about intent, the reason behind that publication or information. We always believe that legitimate criticism is an essential part of democratic discourse, and that should be encouraged, fair enough. But in misinformation, Tanko explained it, and then I'll break it down a little bit, not in the legal language Tanko did, but in the simple English that we all understand. So misinformation often involves inaccurate information that is shared without intent to mislead. And that one you can easily correct it through corrective communication and education, and then bringing out the verifiable information to dispute it. If you can remember, during the 2024 election, we had the coalition of fact-checking institutions who came together and then set up and started churning out fact-checked information from political figures. So statements and all of this were verified, and a lot of statements were debunked along the line. So we know that people churn out information without even realizing that what they have churned out is right or wrong. This information comes in when there's a deliberate attempt to deceive or manipulate. And so sometimes when you receive information that you want to forward or share or anything, we tell you that pause and verify and check. Sometimes you can check from the source of the information. You can do that from it's forwarded. Sometimes you'll be able to find out from the source whether the source is for loss of words is a source that you can go by, a credible source that you can stand up to it. Whether the information, we are in the media landscape, the same information is verified and shared by different credible source of information, or not, because for example, if there's a news that comes up or a source that comes up, the same information is being shared on maybe GBC, GTV, GBC Online. The same information is being shared by City, Joy. That's why verifiable sources, then you are more comfortable to say that this information has been verified before putting out. But later you realize that there's an information and there's only one source. It comes out, normally the WhatsApp do it. You look at it, you see that this information there is being claimed to be shared by TV3. You look at the logo, you see that there's TV3, but the 3 is turned upside down. So let's be careful. Okay, let's be very careful to really critique the information we receive before sharing. So we say stop, verify before sharing. Okay, that is a way of trying to help us not continue the cycle of misinforming people to be caught in the web of that cycle. That's a little I can say about
Thank
it.
you, Doc. That was
I'm going into.
Thank you. All right, Doc. Thank you very much. So, Tanko, where do we draw the line between my opinion and what the law considers as false news?
Yes.
So, like we said earlier on, the questions about what is even fair, reasonable, legitimate itself, people always think that there's an element of subjectivity in these things, but it is not subjective. The exercise is objective. In other words, the things you said, the things you published, it's not how you look at it. It's not how the person who is complaining about it looks at it, but it's how a reasonable person would consider what you have done. Is it something that, if you look at it from a reasonable point of view, is it something that promotes incitement to violence? Does it incite people to violence? Does it really promote or has a tendency to promote real threat, true threats, issues about fraud for financial gain, issues about, child exploitation? These are the 21st century problems that people are having, issues. These are the things. So the intent, did you know, and Nafisa made that very important point, the intent, did you know that what you were putting about is false, or did you intend for it to cause harm, and the imminent nature of the harm, and the link between what you said and what it has caused, whether sometimes somebody says something and then something happened, if you like, remotely, but there's no causation, there's no link between what you said and what has happened, but they try and fit it in there. So, I mean, problematic speech, if we want to be honest with ourselves, every reasonable person knows what is problematic in our context, because we are not living in an island. We are also a creation of different culture and norms. And there is acceptable speech and unacceptable speech. But of course, it has to be actually clothed within the context of the law. So it's about things that you say that or a reasonable person would look at it and say, no, you have crossed the line. It's inciting people to violence. It is inciting people to do things that would bring all of us problems and all those things. So the line is quite clear. It's just that the vague nature of the provisions is what allows people to go down the subjectivity route. But if you have an independent person looking at it, and they look at what you have done as against what the law says, we can always arrive at an objective way of looking at it. And if you arrive at the objective way of looking at it, you will actually end up not having all these, illegitimate attempts to settle personal scores or to protect somebody's image and all those things.
Thank you. Thank you. Nafisa, I think I have one for you, which ties into the work that you do. Somebody's asking, in dealing with mis and disinformation, what legal role do traditional authorities play?
Traditional authorities wield a lot of influence on their people and their power. And sometimes when their statements go far and wide, it's important that they are parts of the collaborators, or should I say, the people we work with and deal with when we are embarking on our public education campaigns and things like that. So from where we sit, from where I stand, from IS's perspective, the opinion leaders or the traditional leaders will be a very strong, should I say, resource persons when it comes to getting the importance of knowing the right from wrong when it comes to misinformation or disinformation. That's the summary I'll put to it.
Thank you. So, Tanko, this same question, as Nafisa was responding to, I was thinking, in the olden days, the traditional leaders had a lot of power in terms of, enforcing certain laws within their own, should I say, jurisdiction. So in terms of issues to do with hate speech in their localities and rumors and misinformation and all of that, how do we fit in traditional authorities?
In a democracy, the rule of law is supreme. Customary law is recognized by our constitution but it is a subordinate law that would always be trumped by the Constitution. Now, the risk is that if you remember, there was a time where a chief in one of the regions asked that a youth should be flogged, should be beaten for disrespectful Facebook post. Because some of these things are about emotions. And so if you bring the traditional authorities into issues about interfering with fundamental human rights, it raises a lot of legal issues. What is their legal basis for doing that? And then the issue of selectivity and all those things, and the fact that in our traditional context, when you go before the chiefs or elders, there are certain things that you are not allowed to do. If you do, it is considered to be disrespectful, whereas in a democracy, that would not be acceptable, because you have to hear somebody before you punish them. But how you hear them would be a problem. So there would be due process gaps, and if we are not careful, it would create more harm than good. I think what the chiefs can do, or the traditional authorities can do, is that we need to get them involved with the faith-based organization in raising awareness and sensitizing people about the issues about, if you like, media literacy, issues about, let people understand why whatever they say, they have to also be responsible. Because sometimes people say something and they don't see the direct link between what they say and how that can affect even their daily bread, how that can affect their work tomorrow, because they don't realize that, okay, this thing that I have said, if it could actually lead to some economic downturn, it could lead to people running away from us and saying our economy is coming on its heels, and therefore people will not invest in your country. How is that going to affect you? Well, if you think you are in gainful employment, so what? What about your daughter? What about your son? So people should not see these things as remote. They are really, really rare, staring us in the face, the consequences of recklessness or irresponsible actions. But what we are saying is that it is a collective effort. We all have to play a role, but whatever role you want to play, or whatever mechanisms we want to put in place to deal with some of these things, we should not do it in a way that would defeat the very purpose. And our public officials should also learn to tolerate and take criticisms in a way that ideally they would not take. Because when you put yourself in public service, there are certain things that comes with it. But certainly, we should avoid a situation where we are trying to make it difficult or impossible or scare people into being open and transparent in asking for accountability. Certainly, that's not the way to go. That's not how developed democracies went, and we don't want to go down that road. We have our own challenges already, and we don't want to add this to that, because that is why we moved away from military era, and we say we are embracing democracy. If we are embracing democracy, these are some of the challenges you would have with democracy. But let's operate within the law. Let's operate within the law to satisfy a general interest, not a parochial interest. And I think if we have the general interest at heart, and not because I don't want my political party to be embarrassed, not because I don't want my leader to be embarrassed, not because somebody has said something that will make my leader unpopular, even if he has no direct bearing to actually causing a general challenge. If we move away from that, I think we'll be making a headway. But I want to emphasize that there's no right anywhere in the world that is absolute. Even the right to life, which you and I would cherish so much, there are instances where taking somebody's life can be lawful. If it is done in the, in self-defense, or even if you like, to execute a lawful order and all those things. So let's be mindful of that and not get carried away where people do and say, oh, we are in a democracy. Democracy itself, my brother Jerry, you and I know that democracy is not purer than pure. It's not a divine sort of system of law. It has its own shortfalls. So let's not be wielding democracy at any given opportunity to push our country into chaos. We don't need that. Let's be responsible in what we do, what we say. That is the way civilized societies operate.
Thank you. Your last comments, the last comments from both of you sound like your closing remarks. So I wouldn't ask you for closing remarks. I'll take this opportunity to, thank you.
No.
To thank you all for joining. But I mean, the key takeaway from this for me is that if there's a shared, principle to take out of this, our conversation, is that enforcement should be a last resort. And I think we both agree that it should be applied in the smallest necessary degree and only where the harm is real and where the law is clear. I hope I'm doing justice to what you guys shared. And also...
more than justice, Reed. You have done more than justice, Reed.
And then also to say that we are fortunate that the law is still not being passed yet, and there's still some broad-based engagement going on. I'm referring to the Ministry of Communications law on the mis and disinformation. And consideration is going on, and we still have an opportunity, all of us on this call, we still have an opportunity to, from what we've just, listened to and learned now, to write those boundaries that we have identified and send it to the ministry. We all of us own it. So that we close the gaps today that allow, the gaps that allow selective or disproportionate enforcement, and also to protect both public order and citizens' right to speak. I don't think we'll be able to resolve, every, hard case today, and we should not pretend to. What we can do is live with a shared understanding of where the lines sit, how they should be enforced, and then, the points of convergence where, we see that we have responsibilities, as Dr. Nafisa said, and then, make sure that whatever we share and communicate does not cause harm. So on this note, I would like to thank, Manasseh, Precious, Dr. Nafisa, Lawyer Tanko, and everyone who has joined this call. That we are very grateful for your time this morning. And please look out. We'll be having a series of conversations around this, all in our quest, to promote information integrity within our space. So thank you very much. I don't know how we can, we'll do the, what's it called, the item 13 here, but this is the time for all of us to go and pour ourselves tea or coffee and enjoy the rest of the day. Thank you very much. All right.
Thank you for having me. Yes.
Thank you.
Thank you.
My sister, all the best. Jerry.
All the best. Thank you. Cheers. All the best.
Yeah.
Bye.
Let's link up. All the best. All right. Okay. Thanks for having us.
Yes.